We all stand up as we welcome our chief guest into the room. Our dear chief guest, Senior Advocate Rwakafuzi, you're highly welcome.
Revising our script, so we are going to delay it by introducing.
We can take up our seats. Good morning once again. Good morning. Ladies and gentlemen, I wish to welcome all of us to this week's press and public engagement session under the Radical New Bar program. My name is Gaudius Tuyasingura, and I'm honored to serve as our moderator for today's week's presser. As we all know, today's agenda is very timely and crucial, as we shall be looking at two critical aspects. One, we shall be receiving the ULS's position, presentation of ULS's position on Friday's court-martial verdict. And we shall also have the presentation of the Demilitarization Award to one of especially. I wish to take this opportunity to welcome our chief guest. Our chief guest, you're highly welcome. Our chief guest today is Senior Advocate Rwakafuzi. I think most of us know him. He's a seasoned human rights activist, constitutional lawyer, and he has done a great job, especially when it comes to the demilitarization of our justice system. We thank you for sparing time. We know it was not easy for you to make it here, but we really appreciate as ULS for creating time to be with us today so that we celebrate you and as we present our ULS's position on the forthcoming Supreme Court decision in Attorney General versus Honorable Michael Kabazuguruka. Still, on the same note, I wish to recognize the presence of the spokesperson of the Back on Track think tank, Miss Nakamia. You're welcome. She's always here with us. We appreciate that. We also have Advocate Jude Byabakama present here. We recognize Byamukama. We recognize you here. We also have Council Derek Bazekuket. Thank you for joining us. Then we also have our dear CEO present here, Miss Christine Awori. We thank you for joining us. Of course, we have advocates here present in the room and joining us online. And to emphasize, this session is live on YouTube, Twitter, and Zoom. So we also appreciate our online audience for joining us. And we can assure you that it is going to be a very wonderful deliberation today. Not take much of our time. In the meantime, I'll take this opportunity to invite our dear CEO to say a word to us. Thank you.
Good afternoon to you all. I'd want to remind us that this is our third Rnb live press and public engagement, and it's now a norm or a culture that we have a guest on that day. So we are honored to have Senior Counsel Rwakafuzi, who is I'll call him a grandfather in human rights, activism, representation, advocacy, and also he has been serving the members of this public on pro bono. Yeah. And we are honored to have him here today to recognize his efforts, his work. And we are so grateful, Senior Counsel Rwakafuzi, that even in your state, you have made it a point to be here. We don't take this lightly or for granted. Counsel Jude and Counsel Derek are very supportive with cases, ULS. So we also recognize your efforts. We don't take it for granted. Mary Goretti, we don't also take you for granted for the pro bono services you give to us. Thank you very much. We also honored to have Mr. Madvan Rwakafuzi, who is here to support our Senior Counsel. Council present here and online, we are very grateful to have you here. Media, we are so grateful to have you here. We are very aware there's another big event happening in town, but we don't take it lightly that you made it here for our weekly program. Thank you for coming. We still have some in-house issues we are settling, and when we settle them, we shall start. Okay? So hang in there. We are going to start shortly. I also want to recognize our head of department at Uganda Law Society. Uganda Law Society, I know you all know, but I'm just reminding you, is the Uganda Bar Association for all advocates and brings us together. So most people or most lawyers are only aware of the other important bit which they are happy with, of that concerns them, the members' affairs and professional development. But I want you to know that under Law Society, we also have other departments. We have a department that caters for rule of law, and we have the head of rule of law here, and she will also speak to us or address us today. Can you please get her for recognition? We have a department which we call legal aid and pro bono services, and that's how I was able to know that Senior Counsel Rwakafuzi has done so many pro bono cases, and how I come to know about it because I head that department. And under that department, I'm assisted by a legal aid manager. Can you stand up for recognition? Under legal aid project, we have 23 legal aid clinics across the country where we give free legal aid services. We give legal aid services to the vulnerable persons. We give legal aid to marginalized persons, indigent or poor persons. We have a way we assess to tell that you're vulnerable, marginalized, before we take you up. And I also want to let you know that among the clients we have received over time and supported, the people in Karamoja, and some of them have been arrested and detained by the UPDF or military. But we've worked closely with the military to make sure that these people's rights are recognized and they're taken to the right courts. And we have supported them get temporary release through bail. But I must say there are some we are not able to reach because as they're arrested in Karamoja, they're detained out of Karamoja. So it's kind of restrictive to find them, to support them. But nevertheless, we shall look out for them and then try and see how to support them. How do we do this legal aid? Uganda Law Society does not have funds to support the vulnerable people. We have the donors reach out to with our proposals, and then we get funding, and that's how we're able to represent our clients. We also have, like I said, Professional Development and Members Affairs Department, which is headed by Miss Doreen Natkunda. She's over there. We also have a department of human resource, and we have our head human resource here. She's over there. We have our head finance, but he's engaged in another meeting. Monitoring and evaluation, Mr. Masava over there. Yeah, it's printed already. So you can send the one. Yes, that's. I know most of you have been coming here and you didn't have all this information. Mostly our journalists and some of the members. So while we are clearing up our in-house, I decided to give you some information you didn't have. Hope you're happy with it. Are we ready? So we are now ready. We have cleared our in-house. And I will deliver today's remarks. The remarks for this week are on our Friday military court verdict, which we are all eagerly waiting for, which is going to be released tomorrow, because there was a notice in that effect that notice is going to be, that the judgment is going to be released.
Recognize the council that is currently watching us online.
Oh.
Yes, you can see that.
Okay. Before I proceed, I already introduced all of us, so protocol observed. Ladies and gentlemen, both here and online, good afternoon to you all. I bring you greetings from the Secretariat, the President, and the Radical New Bar Governing Council of the Uganda Law Society. They are unable to be here physically due to an earlier scheduled council retreat of the Justice Assist Team. On Friday, 31st January 2025, the Supreme Court of Uganda is set to deliver its long-anticipated decision in the landmark case of Attorney General versus Michael Kabaziruka. Constitutional Appeal number 2 over 2021. The judgment is coming after 4 years, and that's when the appeal was filed. It was filed 4 years ago. And it's coming to address the contentious issues of trying civilians in military courts in terms of the Uganda People's Defense Forces Act, a practice with a profound implications for constitutionalism, human rights, and the rule of law in Uganda. Article 23, Section 1 and 126 of the Constitution of the Republic of Uganda guarantees personal liberty and expeditious prohibits arbitrary detention and unfair trial practices. It is the long-standing position of the Uganda Law Society that the continued trial of civilians in military courts represents a blatant breach of these constitutional protections. Military courts, by design, are intended for offenses committed by military personnel, not civilians. Subjecting civilians to the jurisdiction of military courts undermines the independence of the judiciary and erodes a public trust. The unconstitutionality of trying civilians in military courts has been affirmed in the previous landmark cases, including Honorable Mike Kabaziruka versus Attorney General, Constitutional Petition 45 of 2016. We have Captain Amon Byarugaba and 169 others versus Attorney General, Constitutional Petition 44 of 2025. We have Semju Abdul versus Attorney General, Constitutional Petition number 4 of 2018. Despite these decisions, the 240-day delay in delivering the AG and versus Kawazuruka appeal judgment, and the persistence of military court trials by civilians have perpetrated uncertainty and injustice rising from public anger towards the judiciary. Section 3D of the Uganda Law Society Act, CAPS 305, it states that ULS is mandated to protect and assist the public in Uganda in all matters touching ancillary and incidental to the law. Section 3E is of the same effect of the same act requires that the ULS is supposed to assist the government and the courts in all matters affecting legislation and administration and practice of law in Uganda. Lastly, Section 3I empowers the Uganda Law Society to do all such things as incidental and conducive to the attainment of the foregoing objects or any of them. Uganda Law Society's first petitioner to challenge the trial of the civilians in the court martial through constitutional petition 18 of 2005, although it was not successful and was abandoned, its cross appeal on the ground in Constitutional Appeal number 1 of 2006. But as it may, we are pleased that the illustration members of the Rule of Law Committee, including our distinguished chief guest, Mr. Rwakafuzi, Senior Counsel, maintain the struggle in the individual capacities as advocates to their respective clients, including representing clients on pro bono, like I said earlier. We applaud our members' efforts over the course of the last 20 years of this struggle, and therefore expect victory on Friday, the 31st of January, which is tomorrow, in the light of the continued success they have registered at the Constitutional Court. Whatever the outcome, US remains steadfast in the campaign for the following: a clear separation between military and civilian jurisdictions and accountability of the former to the latter. Civilians currently are facing charges in military courts should be discharged and not merely retried. The procedural deficiencies and lack of proper investigations make their cases unsuitable for transfer from the military court to the civilian courts. In accordance with Article 23(7) and Article 1262(c) of the Constitution of the Republic of Uganda, the state should provide adequate compensation for the wrongful detention of these civilians under military justice. Lastly, we take the lead in coordinating justice, law, and order sector players to ensure the effective enforcement of the Supreme Court's verdict should it favor the civilians. Thank you very much. I'll stop here, and my colleague, Head of Rule of Law, as Ms. Afra Apio, will take over from here. Thank you.
I stand on the protocol that was observed earlier. Good afternoon. Should the Supreme Court uphold the constitutionality of trying civilians in military courts, the radical new bar is prepared to take decisive action. We will escalate this matter beyond local remedies to regional and international courts, including 1, East African Court of Justice. We will invoke Articles 6D, 7.2, 27, 30, 33.2, 38.3 of the Treaty for the Establishment of the East African Community, which empower the regional court at Arusha to intervene where domestic courts have disregarded the rule of law, international human rights standards, and under fundamental principles of the East African Community. Secondly, African Commission on Human and People's Rights, we will also petition this body of experts on the African Charter on Human and People's Rights to challenge the continued trial of civilians in military courts in Uganda, excuse me, citing violations of human rights and international law. Thirdly, the UN Human Rights Committee, we will also petition this body of independent experts that monitor implementation of the International Convention on Civil and Political Rights by its states parties. The committee's work promotes the enjoyment of civil and political rights, including the right to a fair trial. Furthermore, we urge the government to immediately terminate the illegal military courts trial and the unlawful prosecution of civilians in military courts. Secondly, discharge the affected victims from the malicious charges, drop all charges against those wrongfully accused, and ensure their freedom. In a nutshell, the radical new bar demands that the government upholds its obligations under national and international law to protect human rights and the rule of law. The ULS remains committed to advocating for justice, accountability, protection of human rights in Uganda. I thank you for your kind attention.
Thank you so much, our dear CEO and the head of the Rule of Law Department, for delivering ULS's position on the forthcoming Supreme Court decision in Attorney General versus Honorable Michael Kabazuguruka. I think we have all listened to ULS's position. At this juncture, I shall call on Senior Advocate Jude Byabakama to take us through the plenary. For those of you that could be having any Byamukama, I correct myself. I shall request all of us that could be having questions in respect to the issue at hand. I know it has been very many years of waiting, and we have very many issues, very many anticipations. So in case you have any issues to ULS, we encourage you to bring them to us, and we assure you that you receive responses that they deserve.
Good afternoon, ladies and gentlemen. My name is Jude Byamukama. I'm not Byawakama. That is the Electoral Commission chairperson. Maybe I should have that job also one day. Just highlights and then interaction. I'm here to answer a few queries on your behalf. But just to highlight, the CEO has gone through the statement, which I think you have listened to. What I think is important, to give you some context, Uganda Law Society has always been troubled by the attempts by the military to conscript civilians into the military justice system. This is something which started in 2005. Ironically, when Dr. Besigye and 22 others were arraigned in the court-martial and charged with terrorism in the year 2005. At that time, Uganda Law Society did go to the Constitutional Court to challenge that practice, and the Constitutional Court agreed with Uganda Law Society. Unfortunately, the decision then was largely addressing a specific question of whether Dr. Besigye and his co-accused could be charged in the court-martial. The broader point of whether civilians, as a matter of principle, should be conscripted into the military justice system was never addressed in that case, even when the matter went to the Supreme Court. And therefore, this whole issue has remained hanging over civilians, like the proverbial sword of Damocles, until the Constitutional Court, in two important decisions, decided to courageously confront this issue and close it. At least that's what we thought. We didn't think there would be appeals by the Attorney General, but the Attorney General has a right to appeal, and there's nothing unusual about that. But what was important was that in the two important decisions, that is Michael Kabaziguruka versus Attorney General, and then Amoni Byarugaba and 167 others versus Attorney General, in those two decisions, the Constitutional Court unequivocally ruled that the court-martial does not pass the test of being a fair and impartial tribunal as required by Article 28 of our Constitution. A fair and impartial tribunal means one where anybody who is charged with a crime can go and expect to get justice. And the Constitutional Court pointed out a number of reasons why the majority, it was a 3-2 decision, by the way. It was a 3-2 decision. The majority took the view that, first of all, when you look at the oath, which members of the court-martial take a judicial oath. Ladies and gentlemen, a judicial oath is taken by every magistrate and every judge of the High Court, Court of Appeal, and Supreme Court. It requires that you should undertake to administer justice without fear or favor, without ill will. In other words, when you become a judicial officer, you commit that when I have this person before me whom I have to try, I must try them without fear or favor. If I need to convict them, I must convict them no matter who they are, whether they are the most powerful in society. Without fear or favor means I should do what I need to do according to the evidence and the law. It also means that I must acquit someone who needs to be acquitted, even if there are people out there who think this person should be convicted. Whether it is the head of state, whether it is a commander-in-chief, whether it is the chief of defense forces, judicial officer is required to act without fear or favor. Now, when you contrast with the court-martial system, the military system, the members of the court-martial take an oath to be loyal to the commander-in-chief. A huge difference. Why? Because the military system is set up to administer discipline in the army. We need the court-martial, and it's not the position of law society that the court-martial is bad, it shouldn't exist. No. The court-martial should exist for administering military discipline to members of the military. Even then, it's our position that when it comes to ordinary to crimes, if a soldier commits an offense of murder, again, that is not supposed to be in the court martial. That is supposed to be taken to the civilian court. And that is how it works internationally. If a soldier commits a traffic offense, you don't take them to the court martial. But the current system, which was created by the UPDF Act 2005, created an overlap where the court martial is literally administering the criminal justice system of the country, which should be the role of civilians. And therefore, over the years, Uganda Law Society didn't take on the mantle after the Supreme Court decision in 2007-8, but we have had courageous foot soldiers, courageous warriors, like our senior advocate, whom we recognize today, Mr. Ladislaus, Rwakafuzi. He was lead counsel in the matter of Amoni Byarugaba and 167 others versus Attorney General. That's a decision which also strongly emphasized that you cannot try civilians at all in the court martial. And his work speaks for itself. That is only a contribution regarding the court martial. He has tried many people who have been tortured by law enforcement, people caught up in mistreatment by the army. He has got a stellar record. We could talk about it the whole day. And that's why I think it was very fitting that the Secretariat and Uganda Law Society honors him, because like our statement says, that has been read, no matter what happens on Friday, we are praying and hoping for the right decision. But again, it's a court. There are 7 justices. We don't know what they will decide. What's important, like our head rule of law has said, there are measures which are in place. Because this is so fundamental an issue. It touches the core of rule of law in this country. You cannot have all civilians being potential suspects in the court martial. As all of us here recognize, indeed, it's also part of the elephants in the room. We have an advocate who is currently in prison. And how did he end up there? Mr. Aaron Chiza ends up there because in the course of representing a client in the court martial, instead, he ends up in the dock and serving a jail term. He's not the first, by the way. In 2005, Mr. Elias Lukwago and Mr. Caleb Alaka were also cited, only except that for them they were sentenced to a fine and a few hours imprisonment. Why? The military system is not designed for us civilians. The way I express myself as a lawyer, when I go before the court martial, the generals and the majors will think I'm being disrespectful to them. Yet me, this is how I make my points. The military system by its very nature is hierarchical. It depends on obedience. It depends on loyalty. So when I'm a general and I'm listening to this advocate, the advocate thinks I'm just there to hear his case and he should make it as he wants. But I think for me, you are in my room, so I dictate the rules, which is not how civilian courts operate. We have had advocates who express themselves differently, and it's normal and it's healthy. But now the military system is a bit unique. First of all, the court martial is sitting in a military establishment. Access, and that our constitution says courts should be accessible to the public. But accessing that system is a problem. When you criticize their decisions, they say you're contemptuous. And the next thing, you are being cited for contempt. It's a dangerous trend, and we are hoping that it can be brought to a close. If it's not against the job of Uganda Law Society, that they must continue. We must continue to ensure the public is protected, to ensure even our brothers and sisters in the armed forces have got a military justice system that is fair to them. That is the overtone that you read here, and I don't need to repeat anything, like has been summarized for you. Depending on what happens on Friday, there may be a need to run to the East African Court of Justice in Arusha. There may be a need to also ask the African Commission on Human and People's Rights to weigh in. In Uganda, we are very good for signing on to international treaties and then keeping them. and then the UN Human Rights Committee. Why? Because once the Supreme Court has closed it, it means that in our domestic courts, it's done. The only other institution that can solve that would maybe be Parliament. If Parliament chose to amend the UPDF Act to take into account the concerns of the public, that is also a possible avenue. But short of that, and given the nature of the politics surrounding this whole debate, where the head of state has made his position clear, that he thinks the court-martial should remain to administer medicine to errant people in some cases, it becomes challenging. And therefore, maybe the international arena becomes relevant. Regional and international institutions would also be petitioned to call in. So with that preamble, I'm open to any questions or comments about this important subject. Who is the... Oh, this one.
Is it a morning or it is already good afternoon? Good afternoon.
Good afternoon.
Yes, I'm Deborah Namamonde. I work with UBC TV. I have only 2 questions. One, as I've heard from the other madam, I've forgotten her name. According to me... Afra Appeal, Madam Afra Appeal. According to me, according to the way I'm seeing you addressing or tackling out your issues, it's like you are intimidating the judiciary to give the verdict in your favor that if you don't do this and this, we are going to do this. If you don't act according to what we think, we are going to do this. I would like to know, what are you trying to insinuate if you try to talk like that? I think another issue is about, still she has talked about the issue of following on that case, not until they reach the East African Court of Justice and sort of, and using other means, human rights and sort of the declarations and treaties and so on. One would like to know, there are other decisions which were made by this court. One would like to know, why don't you start by following those decisions and you take them further, as you promised for this Kabazuguluka and Attorney General's case? One would like to know, what is that is hindering you? Another thing, maybe I may beg to be corrected. Yes, civilians have been charged in the court-martial for all that long. Because since when I started covering news, I've been covering things concerning with court, but I've been seeing civilians being there, being charged and sort of. One would like to know, is the Uganda Law Society or the new radical bar selective if it comes to issues of fighting for people's rights? Because right now we are seeing Dr. Kizza Besigye in court. That's why we are seeing everyone saying, court-martial cannot charge people, cannot charge civilians and sort of. Are we seeing Uganda Law Society and the radical new bar being selective, that it is because of Dr. Kizza Besigye being in court-martial, that is when they are coming out? I would like to know. I thank you.
Good afternoon, everybody. Rogers Magala is my name, from the Daily Monitor. My question is, if the ruling on Friday doesn't come out in our favor, both the Uganda Law Society and the Ugandans out there, apart from what you've said, because the Supreme Court is the annex of justice and the considered mediums of justice outside this country, do we have any option of radicalism? For example, calling out the bar to abscond any duty in court, sit down. Do we have any radical option, like you promised the country before you came into office? Thank you.
Me?
You are part of the radical new bar.
Thank you so much. My name is Judith Kukunda. I work with Uganda Radio Network. It's an online based news agency. So, Council, my concern or my question is, you as the Uganda Law Society, we expect you to be the champions of rule of law. And then we normally hear that there is this issue of sub judice rule. When you come here and you start arguing what you have presented, and you opening pleadings when the case is already closed and arguing again when the judgment is pending just the day after tomorrow, aren't you in breach of sub judice rule? Then I would also like to have some examples of some of the cases that Council Rwakafuzi has like some of the prominent cases that he has handled, especially in the court martial, so that it can enrich our stories. Thank you.
Thank you. I think we can first answer the first three questions.
Yes. Okay. I'll briefly respond to them. Are we intimidating the judiciary? No, not at all. Asking the judiciary to do its job does not amount to intimidating them. Not at all. Because you see, the roles of law society are to sensitize the public. Okay? Members of the public need also to know whether the judiciary is doing its role. The challenge we have had is that this whole thing, the courts of law have become an elitist institution that seems to be cut off from society. Many ordinary people don't know what goes on in the courts until they unfortunately find themselves entangled in a situation that takes them to courts of law. But it's our job to educate the public, even those who don't want to ever step inside a courtroom, that this is actually what happens inside the courtroom. And the judiciary, which is funded by you taxpayers, is operating this way. For example, it spends 4 years to determine one appeal. It does this. It has a serious backlog. All the politicians have appointed very few judges. So when you find yourself, you have a court case and it is taking 10 years, don't say that the magistrate or judge is lazy. Maybe the judge has 2,000 cases to hear in 1 year. It's our job to educate the public. And when it comes to the specific context of this Attorney General versus Michael Kabaziguruka, it's a very important decision. Like I said, Uganda Law Society had done its part years ago. In 2005, Uganda Law Society went up to the Constitutional Court, and the matter was appealed up to the Supreme Court. Over, again, the question of civilians, although that case was restricted to the facts of particular individuals. And so the broader point of whether these individuals should ever have been tried there at all was never litigated to conclusive finality. And therefore, what we are doing now is making it clear to the public. People should know, first of all, if the Supreme Court says, too bad, you can actually be tried there. Everyone should know. Why? The law is also influenced by politics. The laws which the Supreme Court is interpreting, the Supreme Court is going to rule that it is interpreting the Constitution. But the Constitution does not belong to lawyers. It belongs to the public. And so it becomes an internal legal matter if we leave it for the lawyers and we don't bring the public on board. And I believe that is why the Radical New Bar decided to have these engagements more frequently for people to interact and get to know the faces behind some of these matters. One of the challenges we have been having is that very important court decisions, which affect even the ordinary person at the grassroots, are only known in legal circles, by sections of legal circles, and the public doesn't know. So those young children in Karamoja who were being charged in the court martial may not know that they were being charged there because the issues start in Kampala, but they are being charged in a court martial sitting in a beam in Nakapiripiriti. And therefore it's important, the judiciary has a job to do without fear or favor. They take an oath to administer justice without fear or favor. Surely, lawyers saying, your lordships, we are hoping you are mindful of these important principles and the significance of this decision. It doesn't amount to intimidating justices. In any case, we have spoken, they have handled more, you could say, delicate matters like presidential election petitions. So this should never have, I don't think this matter would have attracted the level of attention it had if it had been quickly determined 2-3 years ago. But as we can all see, the delay to determine it has caused so many developments. You have an advocate in jail, you have other individuals being charged by the court martial left, right, and center. I have represented a lady who is also in the Constitutional Court. One individual, I represented her. She was charged and convicted of murder in the court martial. And when you look at the record, oh my. The court martial, these are, you see, they are not lawyers. So legal principles are not something that they will find attractive. So let's be mindful that the judiciary has a job to do. It's a duty of law society to call on the judiciary to do its job. That doesn't amount to intimidating. Maybe intimidating would be what my brother is saying when he says, do we have any radical options after Friday? And that's why I was asking who. I think the options which the professional body has have been listed. Okay? It's not a political activism group. Uganda Law Society is not a political activism group. Okay? It doesn't mean that political activists don't have a role to play in this issue. Okay? But the lawyers' professional body has a separate, different role. We engage legally. We are not saying it is wrong to engage politically. And it doesn't mean that there may be lawyers, members of law society, who will engage politically. After all, the reason why this is even a problem is because there are also lawyers on the other side who think it's not a problem. Is Uganda Law Society, why not take on other decisions? Are we being, is Uganda Law Society being selective? Uganda Law Society does a lot of work. It's unfortunate that maybe it's not been well known to the public. You heard about the Legal Aid Project. For heaven's sake, the Legal Aid Project handles, I don't know how many cases they do now, because when I was a law student, I was a volunteer in a legal aid clinic in Kawale. That was in 2004. They handle a lot of matters. So I do not know, I would have probably wanted this person to be more specific and say, what about this case? Why haven't you handled it? But to say we are selective, Uganda Law Society has a legal aid project. It attends to, it's entirely pro bono for handling indigent clients. Anybody who passes, we used to call it the means and merit test. Is it still there? Anyone, in other words, who goes to a legal aid clinic and is demonstrably in need and cannot afford to hire a lawyer will be represented pro bono for free. So if you have got a problem, you have a relative, you have a friend, they are needed, they can't afford legal fees, there is a legal aid project. Like has been indicated, it has funding challenges. It has funding challenges. It depends on the mass of donors. There has been a debate about having legal aid funded by government of Uganda. It requires an act of parliament. I think that discussion goes on and on for years. But it's not about, but also when you talk about being selective, we have to be careful. There will be cases which are important because they are bearing. It is different. If I have a case against someone and it's between the two of us, even if I'm needed and I go to legal aid, they'll probably pay attention to me. But it will be just one of those other files that they have. But when you have a case involving something like this, you are a civilian, you are charged in the court martial. It has a bearing on so many other people who are not involved in it. And therefore, it's the job of law society to ensure that such cases which have a wider bearing on so many people are given better attention and effort. It's only natural and fair. That would not be construed as being selective. Otherwise, anybody else who has individual need and thinks they need support of law society, the doors of legal aid project are always open, to the best of my knowledge, even when they have had funding challenges. I'm sure the doors are all still open, right? Of all the clinics in all the major towns in this country. The sub judice rule. We misunderstand the sub judice rule. The sub judice rule does not mean that members of the public or lawyers cannot talk about matters that are in court. What the sub judice rule means is we should not litigate we should not litigate in the public domain a matter that has already been litigated in the courts of law. Some countries no longer even agree with that standard on the sub judice rule. And it's a debate again that should continue to happen. But the sub judice rule is not in play. It's no different from you saying, I have a court case, I'm waiting for judgment on Friday. And then I go to my church and I say, pray for me, I have a case, judgment is Friday. Will I have broken the sub judice rule? It's important because to talk about it, the sub judice rule is not intended to gag the public or members of the legal profession to keep things in the dark. It can't work that way. If the law is to develop, members of the public need to know. Members of the public need to know what options exist. If you are unsuccessful in a court of law, now when it is the Supreme Court, because there is no other Supreme Court to go to, it's final. What are the options? Members of the public need to know this in advance, and also especially for those people whose loved ones are entangled in the military justice system and who are waiting anxiously. I know people are thinking it's Dr. S.J., our brother Elon Chiza. Hey, there are hundreds of people in this country who are locked up by the court martial. And it's important a message to be sent to them on what options remain. Mr. Ladislaus Rwakafuzi was representing 169 individuals charged in the court martial. In that case of Rnb Demilitarization and 167 others versus Attorney General. So, there are so many affected. Forget about Honorable Michael Kabaziguruka. He's the face. He's just the face of a problem that is way wider than him. And therefore, there is no selection at all. Uganda Law Society strives to support everyone who cries out for support. That's how it is. So someone wanted to know how many other cases our senior advocate has handled. I've mentioned Rnb Demilitarization and 167 others versus Attorney General. He handled another important decision, Behangana Domaro and another versus Attorney General, where the Constitutional Court ruled that members of law enforcement who torture individuals should also be held liable in their individual capacity. So he has contributed immensely to developing the rule of law, human rights, and the whole demilitarization agenda. Because these are cases trying to demilitarize society. Civilians should have their space, the military should have its space. We should all stay in our lanes, maybe. And so he's played an instrumental role in that. There are so many other cases he has done. Those two are just coming off cuff because they are relevant to the issues we are handling. I believe that is all in the questions that were raised.
Yes, before we take up more here, for our audience that is joining us online, we please you can put there in the chat your questions, any comments, and they will be brought to book. Thank you.
Thank you, Councillor Jude.
Yes, thank you.
My name is Remy Asteza. I write for Daily Express online. My question or concern is one or two. Recently, when the Supreme Court issued a notice of this judgment that we are all awaiting for, several activists, of course, came out and claimed that the Law Society or Radical Nuba is taking credit, undermining their role in ensuring that this judgment comes to pass or is much expected. I wanted to know your stand and how do you plan to involve in those activists who are also maybe part of the bar in their and their efforts in following up these rights cases. Yes.
Okay, Remy, frankly, I would consider it ridiculous for any group to say they must hog all the credit for this or for that. Uganda Law Society looks at a broader picture. The broader picture is you are trying to advance rule of law and human rights. And if you achieve that through activists who are not lawyers or lawyers who are activists, it really doesn't matter. And it's not about who hogs the limelight, who takes credit for what. And that's where that is where we go wrong. What really matters is what has been achieved. Those who want to take credit can always do so. Telling you individually, so many people have contributed to all these efforts. It's not just Uganda Law Society, there are human rights organizations. There are so many. And it wouldn't be fair for any group to say we are the only ones who have achieved this. Oh, so many have contributed. Mr. Rwakafuzi has been handling these cases, some of them. And it was some human rights organization is supporting him. I've been supported by some human rights organizations for some of the people I've represented. Some of these issues are brought to lawyers by non-lawyers. So I don't think it's a big deal who should take credit. We should be happy. If there's a good decision, we should all be happy and say, wow, this happened. We should applaud the justices of the Supreme Court. It doesn't have to be about hogging credit, because this is ultimately, it's a very small issue in the body politic. There are so many other issues to deal with. And therefore, to encourage groups to turn against each other over hogging credit is a wrong way of looking at it. Uganda Law Society, like I've said, has been in this fight before. Right now, the case pending was not filed by Uganda Law Society anyway. It was filed by Michael Guruka. He had lawyers, Mr. Kale Balaka, Honorable Medad Segona. But you see, we build on each other's work. And therefore, Uganda Law Society, as members of Uganda Law Society, we are not going to lose sleep over who did what, who is claiming credit for what, as long as there is no fraud involved. Anyone should go. You people, members of the Fourth Estate, by communicating this to the public, you are also playing an important role. Maybe members of law society, activists, could go have cried, what is the judgment, what is the judgment? But if people don't broadcast it on your platforms, who will get to know? So it's a complementary role, and I do not think we should not encourage it, even you members of the Fourth Press. You should not encourage activists to turn against each other. It's unnecessary. You shouldn't encourage members of the legal profession to turn against each other. You shouldn't encourage different groups in civil society or what to turn against each other. Don't build a narrative of who is claiming credit. Build a narrative of what now, what needs to be done going forward. That's the narrative we should be building. That is what benefits the public and the person at the grassroots. But this narrative of who did what, who is fighting for what, it's an elitist narrative that is not useful to the ordinary public.
Hello. Thank you so much. Joshua Kagoro from NBS Television. Mine is of what we are discussing. The new lawyer is yet to be launched. Have you been, I believe you've been invited, and what's your position on that?
I think that's a question for the Secretary to address that. It's outside my ambit.
Good afternoon, everyone. Michael Deng is my name. I work with New Vision. There's something that is very challenging when it comes to civilians being tried at the court-martial. I want to either pose a question or seek clarification from you. Assuming a soldier and a civilian face the same charges or have been arrested over the same charges, what happens? What happens in this scenario? You take the soldier to be charged at the court-martial, then a civilian at the civilian court? I'm seeking your opinion on this.
Depending on the nature of the offense, but maybe to understand what the current position is. The UPDF Act provides that if a civilian aids and abets commission of a service offense, they can be tried in the court martial. The case before the Supreme Court is to determine whether that provision is constitutional. And there are all those arguments which I have summarized for you what exists as the arguments. So the current position is a civilian aids and abets commission of an offense by a member of the military. Then the civilian will be taken together with a member of the military. Okay? You can't have, what is the ideal practice that we think should be there? You take the two of them before a civilian court. When you look, for example, in criminal case files of people charged with aggravated robbery, murder, you'll find many soldiers who are charged together with the civilians, and the case before a civilian court, it is heard and concluded. And then they are sentenced, end of story.
The soldier, the army officer, and the civilian should be tried before a civilian court?
Absolutely.
Okay, thank you.
Okay, thank you very much for listening to me.
Someone from NBS, you asked a question whether lawyers are invited for the new year law by the judiciary. We are invited, but the number is restrictive because of the facility. Initially, we used all attend, but now the space is not enough. So some members will attend physically and some will join online. Thank you.
Thank you so much for Councillor Jude for taking us through this session. Next on our program, I wish to invite the President's envoy, that is the spokesperson of the Back on Track think tank, to deliver the President's message in honor of the tremendous work that has been executed by one of our own senior advocate, Chiza Rwakafuzi.
Thank you very much. Good afternoon. This is the President's message. Citation for the Radical Rnb Demilitarization Award presented to Senior Advocate Ladislaus Rwakafuzi. Fort Portal, Uganda, 29th January 2025. The Uganda Law Society proudly recognizes and appreciates Senior Advocate Ladislaus Rwakafuzi for his lifetime commitment to the fight for an independent, militarized judiciary in Uganda. Councillor Rwakafuzi, now 63 years old, has dedicated the whole of his legal career to defending the rights of the most vulnerable in our society. However, in the past 20 years, he has distinguished himself by standing at the forefront of the battle against the trial of civilians in military courts. A practice that exploded into a legal carnage after the 2006 general elections, ravaging communities from Kasese to Karamoja and shattering the lives of the countless families caught in its merciless grip. A defining moment in his career was his pivotal defense of retired Colonel Dr. Kizza Besigye and his numerous co-accused. Who faced grave charges of terrorism and illegal possession of firearms before the General Court Martial in November 2005. Through Rwakafuzi's momentum leadership of Uganda's human rights bar, Dr. Besigye secured the transfer of his case to the High Court and established the landmark precedent on bail. This victory safeguarded a fundamental tenet of democracy, that presidential aspirants must be free to campaign and contest elections without the shadow of military justice looming over them. The prosecution of civilians in military courts, enabled by Section 117, subsection 1, G and H of the Uganda People's Defense Forces, UPDF Act, Cap 330, formerly Section 119, subsection 1, G and H of 2005 Act, has cast a dark shadow over Uganda's justice system. As demonstrated by the habeas corpus case of Namugera Hadija, 2011 to 2013, Councillor Rwakafuzi's defiance of the UPDF Act ignited a beacon of hope of thousands of civilians trapped within this deeply flawed system. Though the battle reached the Supreme Court in Namugera Hadija versus Attorney General, Civil Appeal number 4 of 2012, victory remained elusive. Yet Rwakafuzi's persistence ultimately bore fruit in the watershed case of Michael Kabaziguruka versus the Attorney General, Constitutional Petition number 45 of 2016, where the Constitutional Court finally struck down the practice of trying civilians in military courts as unconstitutional. In retired Captain Amon Byarugaba and 169 others versus the Attorney General, Constitutional Petition 44 of 2015, where Rwakafuzi was again lead counsel. The court unequivocally stated, trying civilian is the role of civilian courts of judicature, which do not include military courts. Military courts are intended as disciplinary courts for the UPDF to serve the public interest of maintaining discipline among the members of the UPDF. The UPDF Act 2005, to the extent that it may be understood as conferring jurisdiction on military courts to try civilians, is unconstitutional and therefore null and void to that extent. Through decades of unwavering advocacy before municipal and international courts and tribunals, Councillor Rwakafuzi has fundamentally reshaped Uganda's legal landscape. Though at devastating personal cost, each day in court meant absorbing the trauma of countless clients whose lives were shattered by military justice, while watching his own legal practice erode under the weight of deliberately protracted cases and compensation denials designed to break his spirit and diminish his effectiveness. He chose this punishing path, forsaking lucrative opportunities to stand with the most vulnerable, even as his health faltered and a stroke threatened, to silence his voice for justice. That the Uganda Law Society had until now remained silent as this giant of jurisprudence was systematically marginalized and denied his rightful elevation to senior counsel, stands as a stark indictment of our past institutional failures. Today, we not only honor his extraordinary courage in demilitarizing the administration of justice, we pledge as the radical new bar to pursue his long overdue appointment as senior counsel under the advocates under the Advocates Senior Council Regulations 2018. Amoti, your sacrifice has not gone unseen. Your resilience in the face of calculated systematic resistance, your willingness to be broken so that others may find justice, and your unflinching dedication as your health and practice suffered. This testifies to a legacy that transcends legal victories. Comrade Ladi, you embody the highest ideals of our profession, reminding us that true justice demands not just legal expertise, but courage to suffer alongside those we defend. Your path lights the way forward for a new generation of advocates who understand that the price of your justice, through steep, must always be paid by those strong enough to bear it. Kindly receive this Rnb Demilitarization Award as a timeless token of our appreciation from our president, from our Radical Nuba president, Isaac Semakade. Let him stand there. Bring him closer here to the podium. He wants to be there. Okay, let me just say the Luganda version. No, Luganda version. Okay. All right.
lesser than. You will hear, congratulations, you're in the glory of God. Congratulations, He has done it for you. And you will come back with a new song to sing. God is good. Yes, you will come again with a new song of praise. God is good. Oh, congratulations.
Hello. I'm very grateful for the award. Thank you very much. Well, you see, legitimate expectation is the bedrock of justice and fairness. So a person who takes the right foot should not fall into a pit unless he has committed an offense, which is very well known. So a person who takes the right foot is legitimately expecting to pull the left foot again also, because we live on a legitimate expectation. So rule of law is the basis of is based on legitimate expectation. So I can see many of you are very young. You people, I was there the day Amin was overthrown. I think we were on holidays, the long vac of 1971 in January. We were on holidays. I was there. So you people, some of these things you see today happening, I saw them myself. I saw them, and I was at the university, I think in my second year or third year. I think my second year, I was at university, 1986, when the NRA rebels came. They came and they imposed the peace in Kampala, and they were all very happy. You see, they really ushered in peace. It's as if they brought it in a bag and ushered it there. And peace was imposed. You know, life had been very, 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 very dangerous at the time. I remember one day I was walking from Wandega Market, and I just survived a bullet from within Makerere University. So those were very bad times. So these people, when they came, they really solved a very big problem. But you people, you are very young. I can see that things are going back to where we came from. If we don't stand up and demand that we need the rule of law, we shall go back to where we came from. And it's going to be very, very difficult to come back. Legitimate expectation should be for us all. As long as a person has not committed an offense, in other words, for that person to become liable to be indebted to society, then he has no debt to pay under the criminal law. So you people, I'm encouraging everybody of you here present, wherever you are, we should really look to strengthen the rule of law. Okay, I've been down with a stroke, and I saw what happened in 2001, because everything was online. I saw blood on the streets during that election. It is very, very, very sad. I think we should not go back to that. Everybody should, either through prayer or through whatever a person can do, we should do something in order for us to have rule of law again. It's very unfortunate that the people who ushered in peace are also bouncing it anyway. Ushers are also bouncers anyway. Well, I was reading online, people being abducted. Those are the things which were really condemned by people who came in 1986. People being abducted. You people, we need to do something. Everybody in his own right should do something to make sure that we don't go back to where we came from. It was very bad. It was very sad. Okay, the cases I've handled, there's one case which has not been mentioned. There's the case of Karugaba versus Attorney General. The case of Karugaba was Attorney General in 2000. In the year 2000, there was an Irish priest, a missionary in Karamoja. He was called Father Francis Otole. Father Francis Otole was robbed of some money by some soldiers, UPDF soldiers. So, and they robbed him and killed him. Then in Karamoja there was no war at the time, but they wanted the government had an intention to pacify the place because it was because of cattle rustling and so on and so forth. There was a lot of insecurity. Government had put their soldiers to pacify the place. So Father Francis Otole was robbed and killed by these soldiers. Then Major Wamala, Major Semakula, at the time, I don't know where he is today, announced that the soldiers have been arrested and they would be tried and executed the following day. That came out in the Sunday dailies of the. I don't know. I don't remember the month, but that's what Semakula said. So those soldiers were tried. I think there were two. They were tried, convicted, and executed immediately. And then, for us as lawyers, we had to think very hard. Was this execution constitutional? So we realized that the field court marshal had the jurisdiction to do whatever they did, but the problem is, could they sentence a person? Can a field court marshal act in a place where there is no war? Because that place had not been gazetted as a war area. So we went to the Constitutional Court. The Constitutional Court said that the Constitution in Article 22 says that you cannot execute a person after conviction unless that person has been given an opportunity to appeal up to the Supreme Court. So the Constitutional Court said that it was wrong, the execution was wrongful. So we started these things some time back. When we filed that petition, the Uganda Law Society joined it. So it became Karugaba together with Uganda Law Society. That was in 2002. But the Constitutional Court said that everybody who exercises judicial authority in the country is exercising it on behalf of the people, because judicial authority belongs to the people in the Constitution. As long as you have that delegated authority to exercise it, you must exercise it within the constitutional bounds, which include according the accused person the right to a fair trial. So the Constitutional Court emphasized the fair trial. Okay. There are several other cases. Then, I think in 2007, okay, let me say this also. How did the court martial start trying civilians? In my opinion, what happened is this. In the general election of 2001, I think many of you were very, very young, very, very young. For us, I was already practicing advocate. So I saw what happened. There was a lot of thuggery. Actually, that election was so bad. there was so much thuggery. People were using guns recklessly in that election. And if you go back and read the findings of the Supreme Court in that election, in the petition, you'll find that all those things were proved, that there was so much thuggery. So now these thugs who were robbing people became a problem to government because they had been given a kind of license. They thought they can go ahead and continue getting wealthy by robbing people. So how do you manage such a crisis? So they decided that the constitutional, that the field marshal, that the court martial shall try civilians. It was really for managing a crisis that the state had created itself. I was in court. I represented many people in 2001 when were the first chairperson was Mr. General Tumwine. General Edith Tumwine was the first chairperson, and he said some of the cases, he dismissed some of the cases and said they were not fit to go to him. I remember I was representing, there's one of the people I was representing had been a building at a certain site, and the owner of the site alleged that a doorbell had gone missing. So this young man was beaten up and tortured and brought to court martial and charged with robbery. So Tumwine dismissed those cases. He transferred them to Uganda Road Court. He said they did not fit to be tried in that court. So the thing is this: that court can be abused because there's no DPP, there's nobody to sieve out the chaff. The court can be abused. And let me tell you people, a person is not supposed to lose his liberty. A person is supposed to have his liberty, in other words, to be free to move. But the Constitution says if you commit an offense and the court has tried, you are in court, you can lose your liberty. So once the legal process is set into motion, the legal process should be set into motion for a person who really, there is a likelihood that that person has committed an offense. Because even the Constitution says there must be a likelihood that a person has committed an offense. That likelihood should not be through conjecture. It should not be through a whim. It should be through real. That the suspicion should be reasonable. It should have been arrived upon through investigations. Now the problem with the court martial, there are no investigations. Okay, the military does its own investigation, we don't know. But then, for me, the cases I've handled in that court, really, like that case of the doorbell. There are so many such cases that have ended. Then, in 2006, 2007, actually the Supreme Court, in the late judgment of Justice Mulenga, said that a person who has nothing to do with the military should not be tried in military courts. So what the military did, all the people they had arrested, they would say, "We have been found with a weapon, ordinarily the monopoly of the UPDF." They amended the charges and said so and so is being charged with being found in a possession with a weapon, ordinarily the monopoly of the UPDF. Now the problem with that is there's a problem with that one because you see, there was one case of Hadija Namgero. Hadija Namgero was a paternal aunt of Salim Muhammad. Now Hadija Namgero came to me seeking a representation of her son, of her nephew. Salim Muhammad had been found with a star pistol in Makinde there, and charged with being found with a weapon, being a monopoly of the UPDF. Now a star pistol, how can you say it is the UPDF has the monopoly of the star pistol. When you read the Firearms Act, actually when you read the Firearms Act makes most of those weapons are licensable, including SMG. All those are licensable weapons. Of course, there are weapons which are not licensable, like for example, a tank. If you have a tank, and that is one is really the monopoly of the defense force, or grenades or that kind of thing. That one should, on the face of it, is ordinarily the monopoly of the UPDF. Go to the court martial and be tried there. But really, it is very unfair to try civilians in court martial, because that court has been abused, and we need to do something about it. And you see, for example, if they say that you have been charged with the aiding and abetting the commission of a service offense by a person subject to military law, even that one is a problem, because you see, aiding and abetting is an ingredient of an offense which must be proved through trial. If it is an ingredient of an offense to be proved through trial, for example, at one point, after the prosecution has presented its case, the court must rule whether there's a case to answer or not. How about if the court says that actually it's not true, that there's no evidence that you aided and abetted this crime? That one is a problem. A person shall have already gone through, shall already have lost his liberty and a legal process that is unlawful. So you people, I'm calling upon everybody of you, whether through prayer or whatever that can be done. And let me tell you people, I was here in 2003 when the Constituent Assembly statute was being debated in the NRC. Was it NRC? It was not Parliament, because Museveni was still the chairperson. It was the NRC. So the Constituent Assembly spent more than 9 days, actually spent the longest time on the chapter on fair trial, because there was so much to be said. For example, there was the Public Order and Security Act. You people, you didn't know about it. The Public Order and Security Act gave the power to the Minister of Internal Affairs to think, if he thinks that so and so has committed an offense, that person can be detained. The Public Order and Security Act was eventually repealed by this very government, because they said it was a very unfair law, because it meant that people are being taken to court without trial. Then lastly, I've told you of the case of Hadija Namgerwa. Salim Muhammad was charged with being found in possession of a star pistol. Now the star pistol, eventually, the Supreme Court said that if you are found in possession with a weapon ordinarily the monopoly of the UPDF, then you are supposed to be tried there. So when we were leaving court, I saw one of the judges, I can't mention his name now. One of the judges had his pistol from his pocket fall down. And to me, it looked like a star pistol, but anyway, he was a judge. I don't know if he had had that pistol even in court, but you can see the unfairness of this, some of these things. You know, I have a lot to say, but I think I've said enough. Thank you very much, Radical Nuba, Rnb. Thank you very much for the award. I'm very, very indebted to you. I believe I will soon be able to go back to court and do my work, because I still have many people still waiting for me. You see, procedural law is as important as the substantive law, because procedural law, it goes to how a person is brought to court and how he's tried and so on and so forth. Okay, I think I've said it all. I pray that you people, you are young, you need a better country. For me, I had a very good opportunity. NRA had come here and imposed peace. I did my practice. I produced my children. This young man is a lawyer. So I'm very grateful to the NRA people who came and imposed the peace here. But that peace was through legitimate expectation according to the law. So, you people who are young, you still have to found a family. I pray for you that things don't become bad for you to have to look at what we went through. It's very sad. Thank you very much.